The Federal and Thomas Hospital Puliangudi jointly present the Tenkasi Marathon 2025. This event is co-presented by Selvarani Readymades and powered by Repco Home Finance and Sriram Nalamani Yadava Educational Institutions. Run for Health on Sunday, June 29.
Today, our discussion is one of the most hot topics in Assam. That is the pushback of alleged illegal migrants to Bangladesh. The Assam government claimed to have sent 303 suspected illegal migrants to Bangladesh ever since this controversial exercise began earlier this year. In a major embarrassment to the government, however, 64 people had to be taken back amidst allegations that even genuine Indian citizens are being deported secretly. Now, Assam Chief Minister Himanta Biswa Sarma announced in the state assembly that his government will invoke a 1950 law to push back more suspected foreigners. So, to make sense of this alarming development, we have today with us senior advocate of the Guwahati High Court, Mr. R.P. Sarma, Ram Prasad Sarma. He is also a Congress leader and who has switched over to BJP not too long ago. So he can give us some BJP perspective to whole issue also. So, Mr. Sarma, to begin with, is this pushback legally tenable?
Mr. Samir, yes, this is legally tenable in the sense that when a man is caught, suspected to be illegal immigrants from East Pakistan or Bangladesh now, then the authority of the police, they say, whosoever the central government has authorized under the 1950 Act, I think state government or officers of the state government, if a police officer, he or she will have to examine whether what document is or are in his possession. If he can show there is pre-1971 migrant, there is prior to 25th of March 1971, then he shall be further questioned whether he entered India prior to 1/1/1966 or thereafter. If he has entered India, if he can show that he has entered India prior to 1/1/1966, that is the first cut of date. Then he is let off. There will be nothing. If he can show that he entered India all right, illegally as a foreigner, post 1/1/1961, but prior to 25th March 1971, then he will be prosecuted as a foreigner in a foreign tribunal. First, there will be reference, then the play of Foreigners Act and the Foreigners Order 1964 will come into play. Otherwise, if you cannot show anything, there will be three types of illegal migrants. Sorry. One is who has just entered illegally or is trying to enter and has entered inside, just stepped into India. Then he can be just pushed back. Then is pushing back. Second is one who has come to India with valid passport and visa, but overstayed here illegally beyond the limit prescribed under the visa. He has to be found out and deported or sent to his original country where from he obtained the passport. There is Bangladesh. Third is totally illegal, who entered illegally, stayed over in India illegally, and is residing in the territory of India. Maybe he might have acquired the land or he might have acquired some documents thereafter also. Then he can be directly picked up, questions him, the police officer, concerned authority will question him. Then if he is seen, then if it is to the satisfaction of the law is, if the in the opinion of the central government or the authority authorized by central government or the state government, he shall be then pushed back or sent back to Bangladesh. There are three types of immigrants. Now, in case of these two types, first entry illegally, he will have to push back, trying to enter, suppose 10 feet inside India, he will push back. What is the category I told that He is illegally, without any valid passport or valid document, or not being certified by the government of India or its authority to be a refugee from Bangladesh, then he can also be pushed back on verification of his documents. Now
Yeah,
the second category I told you is regarding valid entry, valid living in India to the time as prescribed in the visa. He may be either pushed back or he may be tried under the Foreign Act as well as Passport Act. But they, as you have said, for decades, decades must mean beyond 25th of March 1971. There is 36 years, but 35 years, no, 55 years from hence. From today,
right.
55 years. Right. Then there is cut-off date in any cases, which was under the Assam Accord as well as the IMD Act, which has been struck down by Supreme Court in 2005. So
Ah,
these two things he must satisfy that he entered India prior to 25th March 1971. Then the over what decade will come or decades will come. If he has entered India after 25th of March 1971, but he is stayed over in India, then in his case, the case will be different. Then the police officer at the border police will ask him first if he cannot show that he is entered legally or beyond before 25th March, then he will be referred to the Forest Tribunal under Forest Order 1964. And procedure is prescribed there. There is short procedure, it is a sort of summary procedure, not as detailed as civil case or criminal case. Then he can be prosecuted, or if he can show any document, either land document, even voter list or education certificate, LIC document prior to 25th March, then he will be asked to register before the SP concern of the district for 10 years, and for 10 years he will be non-citizen. No, this act is applicable throughout India, but especially for Assam because this name is Immigrants Expulsion from Assam Act 1950, but it is applicable to throughout India if the government of India so notifies. So, on the conditions I have said, on the qualifications I have already stated, one can be pushed back without following the procedures of Foreign Act.
So,
Because
but
it's a special law for one thing, Mr. Samir, this is a special law for Assam because it has not been made applicable to throughout India. So, a special law for Assam in view of the huge number or large scale immigration post partition. There is a tribunal if the person who is being caught, if he can give a satisfactory application to the concerned authority that I want to challenge it before the tribunal, he can go. I already told you the case of Maulana Abdul Jalil of Badarpur, Kasar. He entered India illegally and he was caught by the police. In that case, he claimed that he is protected under that very act, that is 1950 Act, under the proviso to Section 2 of the Act. Section 2 is the empowering act who is authorized the authority to push back anybody or deport anybody. But under that, I am reading out, provided that nothing in this section shall apply to any person who on account of civil disturbance or the fear of such disturbances in any area now forming part of Pakistan, now it is Bangladesh, has been displaced from or has left this place or residence in such area and who has been subsequently residing in Assam. In that case, he is protected. So he will take the plea. In Maulana Abdul Jalil's case, what happened? When he was caught, he was already settled in Badarpur area in Kasar district. Now it is under Karimganj district. Then Kasar. He was detective police. Then he took the plea. No, though I am a Muslim, same religion, the major population is there in East Pakistan. But due to disturbance and fear of my life and life of my families and properties, I had to enter India and reside here. He took the plea and his case was referred to the Foreign Tribunal, Silsar or Kasar Foreign Tribunal. Ultimately, he won the case. He could justify, yes, he left Pakistan, East Pakistan, out of fear of civil disturbances, and he was protected. Later, the Kasar district, then the district could issue the citizenship certificate. He becomes citizen of India. Now, Assam government is not implementing it; is still pending in the Supreme Court. There are many controversies in this when the NRC was prepared, there are some allegations of serious corruption also there, and the person who was in charge of the NRC in Assam, he is being prosecuted and criminal cases are filed against him also by some authority and some persons. Now, question is, when the actually the government of India and the government of Assam at present day wanted to protect those minorities who are minorities in Bangladesh, like Hindus, Buddhists, Sikhs, and the Christians. And in the list of NRC, it was found out of some 19 lakhs, perhaps. Majority of them were minorities of Bangladesh. So the government of Assam was dithering whether to implement or not to implement. Then the government of India brought Ka, which I opposed it because in the sense I told no need of new act, it will create lot of controversy among the indigenous people in Assam. I had advised the then Home Minister Rajnath Singh and others, and they are satisfied. My simple plea was, if you want to protect the harassed minorities in Bangladesh, like Hindu, Sikh, Christian, and Buddhist, then you can do one thing. Just there four words in the proviso to 1950 Act. That will be sufficient, because here is out of civil disturbance. Who would come by this proviso? Everybody can come. A Muslim can also come. If that is so, then already it is protected. And if you want to ensure that Muslims should not come to India, because it is a BJP government, which claims to be Hindutva government, then I advise that you do one thing. Those entering India for fear of disturbance or due to disturbance, or either for religious or social persecution belonging to minority communities of Bangladesh may be protected. Only the 3 or 4 words were to be added. They do not create any controversy because already Act was there, proviso was there, and this proviso does not define or does not restrict to particular religion. That so religion may.
But this 1950 Act, because it was felt that it is so arbitrary, that's why later on these foreigners provisions for foreigners tribunal were created. And in Assam, there are so many foreigners tribunals. Now, if this arbitrary power is given to the district authorities to just simply push back somebody on the basis of suspicion, then where is the need for this kind of tribunals?
The Samir, already Supreme Court has upheld this act and the provision thereof. So if the Supreme Court has upheld it, then though there is no other forum in India to either challenge it or question it. So because most Tribunal Sonwal case of 2005, 1 and 2, in 1, the this act is also being upheld, and in 2, that one foreign order 2006 was passed, that was passed, because that amounted to some protection to the minorities in Assam.
Okay. So, so you essentially you were saying that these people doesn't have much protection from the law. Anybody can pick them up and say you are Bangladeshis, and can they throw them out of India? That is the scenario.
Yeah, that is the scenario. That may be the scenario because of the empowerment given by this act to the government authorities. because he had
Okay.
no procedure prescribed. Only the authorities to form the opinion. May I read just one line?
Yes,
What
yes,
is it?
please.
Power to order expulsion of certain immigrants. If the central government is of opinion that any person or class of persons having been ordinary resident in any place outside India has or have whether before or after the commencement of this act, even before who has entered, then we push back. Before passing of the 950 Act,
Okay.
act come into Assam and that they stay of such person or class of person in Assam is detrimental to the interest of the general public of India or any section or any scheduled tribe of Assam, the central government may, by order, direct them to be pushed back. So it is
So
very
this is a
giving wide power.
so this is a very draconian law. It's very alarming. Tomorrow, anyone can be picked up and can be pushed back to Bangladesh, and then
So yes,
the
anyone.
person will have to fight legal battle from the other country, and Bangladesh might not even accept them as their citizen.
No, if the Bangladesh refuses to accept them in the border, then the controversy will arise and there is a chance for the person to immediately impose the tribunal. Before whenever he is caught, he may immediately send an application either through email or email to the authority concerned that I need to be tried because I am not illegal migrant. Is defined
But
under
which
the
authority?
950 Act.
Which authority? The authority which is perceived to be anti minorities, and they are pushing back, selectively pushing back certain community. So
The,
again, going back to this authority, will that bring any solution?
no, the authority is authorized by the government of India. Or the government is again delegated the power to the state government. Any subordinate to the central government, any subordinate officer to the central government or the state government. So this also applies to Meghalaya also. This
Can
act.
they directly
So
approach to the foreigners tribunal through email?
if they apprehend, suppose before, the yes, I will be pushed back. I will be sent back to Bangladesh, or I may, or maybe a class of people are being sent back to Bangladesh. Then they can immediately approach the tribunal, or even the High Court also directly. High Court may direct yes, he may try it in the country. He may send back the case to tribunal.
Okay.
So this is the
Okay.
problem.
Okay. Thank you, Mr. Sarma, for
Okay.
giving us the perspective about this very draconian law. Thank you. Thank you so much.
The Federal and Thomas Hospital jointly present the Tenkasi Marathon 2025. This event is co-presented by Selvarani Readymades, powered by Repco Home Finance and Sriram Nallamani Yadava Educational Institutions, along with associate sponsors Treasure Island International School, Homeway Properties, PPR Power Tech, and Premium Samsung Cafe. Run for Health on Sunday, June 29. Entry is free. All are welcome.